meeting today. It's 1:05. This is the first meeting of the rulemaking stakeholder group, and we're calling this Group 2. Group 2 is the group of regulations that the division has carved out that we would like this group to consider modification, keeping them the same, modifying and or writing new regulations in some case. So, per the agenda, just let me say before we do opening introductions, I always have to say this on the record. This is a recorded meeting. This meeting, the recording of this meeting goes on our website. It'll go on our website within the next few days to a week or two. It has to be on there so anybody in the public sector or the rest of the board members can listen to this, the discussion that takes place here. So I always caution everybody to be on your best behavior as far as professional decorum, and try not to interrupt each other so the record is clear. We start with, because it's a recorded meeting, introductions, and I'll introduce myself for the record, and we'll go to my left. My name is Bruce Loff. I'm the Division Director and Executive Secretary of the Colorado Motor Vehicle Dealer Board.
Chris Rouse, Colorado Department of Revenue, Auto Industry Division.
Frank Ingles, Auto Industry Division, Supervisory Investigator.
I'm John O'Beacon with the Auto Industry Division as well.
Gloria Breeden, Compliance Investigator with the Auto Industry Division.
Chris Hartman, Auto Industry Division.
Arlene Tapanen, Recorder.
Michael Dahmer, on behalf of the Colorado Automobile Dealers Association.
Matthew Groves, also the Colorado Automobile Dealers Association.
Steve Perkins, Used Motor Vehicle Dealer Board member, independent dealer.
Jason White, Motor Vehicle Dealer Board, new member.
Leland DB?
Aide, I'm the assistant, I'm the legal assistant. Yeah.
Bradford Jones, Assistant Attorney General, General Counsel to the Motor Vehicle Dealer Board in the Auto Industry Division.
Occasionally during the introductory process, people forget who they are. So.
Yes.
Group discussion guidelines, number 3 on the agenda. What we will be doing today is going through these rules that have been noticed for the group one by one and just getting some first blush feedback from the folks in this room. Probably the real work starts after this meeting when we ask for written comments, if you're inclined to do written comments, so we have the ability to do some rough drafts if needed prior to the next meeting. So what we have done is we've carved out these, I think there's 11 rules we've carved out, and we'll have a group discussion on them. So the meeting scope, obviously, is number 4, number 3, number 4 sort of go hand in hand. We'll review the existing regulations that are above on the agenda, including the impact, if any, of Senate Bill 240, and consider the proposed regulations above, including the impact of Senate Bill 240. So review and consider proposed regulations. At the end of it, if there's public comment, members of the public come in and want to comment, public comment. And we've already set the second meeting working group of this group for next Thursday, September 28th, beginning at 9 a.m. in this room, and we will spend however long we need to spend in that meeting. And that meeting could be much more lengthy than we've had in the past because we have 11 rules to talk about. Okay, and then we will decide next meeting if there's a need for a third stakeholder meeting before we draft rules for notice to the Secretary of State's. For the record, I have seen Mr. Bood, Jerry Bood, come in. Mr. Bood is Executive Director of the Power Sports Association, so I just want that on the record that he just stepped into the room. With that, is there any questions on process today? We're just going to have a a general discussion today. It's sort of where everybody can. With that said, as I look at these 11 noticed rules for review for this group, I do want to take them a little bit out of order, and the reason I want to take them a little bit out of order is number 1 and number 2, I believe, will take some lengthy discussion, debate, history. I can certainly give you the history on 12.6.102.16 as far as the off-premise permits, and I will do that. But because that will have some possible long-term impact to the industry, depending on what happens with that rule, I want to save that to the end. So I want to jump to 12. Yeah, well, thanks a lot. So, this is my copy. That's your copy. Okay. So we will begin, as I have been dressed down a little bit here, we'll begin with number 1, 12.6.104.3E. Now just so everybody knows, what staff did is a few days ago, staff got together for probably a 2-hour meeting, and I'm going to give you what staff thinks about some of these rules based upon our experience in just general, and then just open it up for discussion. So if we look at the current regulation, which you will have a copy of, it was last emailed out by Mr. Beebe to everybody, the regulation 12.6.104.3E. I'm sure that I had a brief conversation with Mr. Donald in the hall, and he spent some time looking at this a couple of days ago. When the division looked at 12.6.103E, my notes to myself, and staff jump in at any time, everybody else jump in at any time, we looked at it and thought, well, it's probably not broken. The division at this point in time are not going to suggest changes to this. We're not opposed to changes, at least discussion on that. But we look at it as it's not broken at this point in time. And if it's not broken, if the group agrees that it's not broken, then we just push that forward and not notice a proposed change. But if there is some discussion that we need to talk about, kind of now's the time to kind of raise whatever issue we have, and then we can bring it back in written comment and talk and really get down to the nitty-gritty if those are some concerns at the next meeting. So 12.6.104.3 is open for discussion.
Mr. Zuloff, if an affidavit of probable cause is issued and approved by the board, and it's the way I've seen them served on dealers, and that's what we're talking about here, right? Failure to respond to an affidavit of probable cause? No, Chris is shaking her head.
Notice of hearing, notice of charges.
What's that?
This would be in reference to notice of hearing and notice of charges, not the affidavit.
Okay.
It's the notice that's drafted by the Attorney General's office based on the finding of probable cause in the affidavit by the Motor Vehicle Dealer Board.
Yes, and that's what I was trying to get at, is how service is accomplished and what happens when a dealer doesn't respond to that service. And because I know that happens sometimes. I know you get an affidavit of probable cause, and typically you send it out with a cover letter to say, please contact our office to discuss resolution of this charge. But what happens, how is service effectuated? What happens if a dealer doesn't respond to that correspondence?
What happens on that, so the affidavit comes in, and you're absolutely right, the affidavit is copied, and there is a cover letter. And the cover letter basically says, because the board has made a motion to allow the executive secretary the authority to attempt to enter into some kind of stipulated agreement if both sides can agree. So that's sort of what this cover letter says. It's not mandatory that the dealer comes in, but it is suggested that it is, and most do. So when there is not a response to the initial letter, not that some don't slip through the cracks, but we generally wait a couple of months, and then Arlene comes in and says, they haven't responded here. So we send out a second attempt letter, and the second attempt letter just says this is a second attempt to look at it. If there is not, if the dealer still fails to get in touch with either Arlene or myself, what happens is then we look at, are we sending it to a bad address? Did it come back undeliverable? And is there any way for us to get a better address type
Right.
situation? So I'm not saying we make a third attempt, but at times we look at that. If it all fails at that point in time, because they just either don't respond or it's totally undeliverable and we can't find them, then I package up, my staff, not me, packages up the entire case file, the investigative case file, and we send it to the Attorney General's office, and I request that they do a notice of charges, notice of hearing at that point in time, and then that starts the Administrative Procedures Act, sort of.
Okay, and then that kicks over to the APA, which dictates the procedures from there. Okay, and that makes sense. Now, what about the orders, though, from the board that are for an immediate suspension of a license? Are those handled differently?
Okay, the summary suspension?
Yeah, summary suspend, that's the word I'm looking for, Bruce.
Okay, so
thanks.
what happens is occasionally there's an affidavit that comes, there's an investigation that comes forward, and we have some internal controls here where the investigator discusses it with their direct supervisor. Their direct supervisor says, yeah, I think this rises to the level of going to the board. This happens on every affidavit, but this one, wow, there is consumer harm here to a very high level. Perhaps this should be a summary suspension. Then it goes to the agent in charge. The agent in charge takes another look at it. And if it's just going to the board, sometimes the agent in charge and the chief of investigations has a third conversation. But if it rises to the level where we think, meaning that group of people thinks, this one is one that the board may want to consider summary suspension. Then it comes to me and there's a discussion, does it rise to this level? Are we going to ask for the board to consider a summary suspension?
Right.
And then I make the determination, yeah, I think it's okay if you recommend that the board has that discussion. We rarely, if ever, say, we think you should summarily suspend this. What we try to say is, we think the board should have a discussion on the merits of summary suspension. So then the board has that discussion, and if the board then makes a motion for summary suspension, then what happens is, generally speaking, not every time, but most of the time, the Attorney General's office is given that documentation that day. The Attorney General's office may even the day before have knowledge that the board may do this. The Attorney General's office then does a notice of summary suspension. We do two services there. We attempt every single time to do personal service on that. So the investigators go out and personally serve, ask them to post the signs, summary suspension, those kind of things, and then almost immediately, then it comes back to the division, and almost immediately Mr. Beebe prepares the same order and mails it per the statute.
Okay.
So then that's what happens. And then what happens is, those cases, because a summary suspension, virtually for every dealership, certainly for a franchise dealership, will become fatal. In a franchise dealership, it becomes fatal within 3 to 4 days. Other dealerships, used dealerships, it becomes fatal probably within 30 days to 60 days. They can't hang on.
Right.
We attempt then to set that hearing. We ask the Attorney General's office to do a notice of charges, notice of hearing, and set that back before the board. With very rare exception, and there's going to be an exception on one of these, but with very rare exceptions, does the board not hear those and try to hear those within a 2-month period of time because of that issue of it could be fatal if it goes any farther than that. We already know that if we send it, if the Attorney General's office sends it to the ALJ, the ALJ looks at it a little differently than a normal case, but they are so buried in their docket, the chances of them getting it before 4 months is probably kind of slim. So,
Right.
So the division takes summary suspensions seriously, knowing that consumer protection, which is our #1 issue, but also that this dealership, if the board determines summary suspension is valid and needs to happen, that the chances of this dealership surviving is minimized. There are cases that it hasn't been fatal, but it is minimized.
How often do you have a situation where there's an affidavit of probable cause that's never responded to by the dealer? Does that happen frequently?
Okay, so we take, I'm just gonna throw out a number, and I'm gonna be in the ballpark.
Right.
We take 120 affidavits in the course of a year, 6 times 10 times 20, no, that's too many. It's close, 100 affidavits to the board, roughly. I'm throwing out real rough numbers a year.
I'm not going to hold you to it. I'm just curious to see what kind of non-responses we have.
Probably out of the 100, maybe 10.
Okay, so maybe 10%.
Yeah.
And just for clarification, the ones that tend not to respond are the ones that aren't in the business anymore and have
Anymore,
gone
they're-
by the
they've closed,
wayside.
right.
They're generally, not folks that are intending to stay in the business or trying to stay in the business.
Yeah. Okay.
In many cases, they'll have left the state.
Right.
In some of those cases. So this particular, the narrow scope of this regulation really has to do with the notice of charges, notice of hearing, and the executive secretary has delegated the authority to enter into default of the license if it fails to answer, okay? I have used that delegation very rarely, because I'm not necessarily, I think I would like to keep that, but I think that most of these cases need to go back before the board when there is a default.
Right.
Any other questions, concerns, input on 126104 3E?
Mike, I'll just mention for you, for our process, when we file notice of charges, we do proceed under the APA as you mentioned. And in terms of providing notice, the APA says it's either served personally or by mailing by first-class mail to the last address furnished by the person to the agency.
Right.
So.
Right. And, and personal service is going away in our world. I mean, we've got mail service in federal court and bankruptcy court now, and so personal service is sort of a dying thing, but it's what I grew up on and understand. And, I don't have a problem with how service is handled now. I was just curious about the service procedures and the default procedures that would happen, from a due process standpoint. So I don't necessarily have any issues with the current regulation, which is mirrored in 104 3E, but I did want to have a good understanding of what kind of numbers we were talking about and exactly what the internal procedures were to address those.
And you are absolutely right, personal service is kind of going by the wayside, but I too am from the old school, so
Right.
I always attempt that. So let's do this, let's move on, and if anybody, after you get back home in the next few days, get back to your office, if you have any other issues with 3E that you think needs rewording or tweaked, attempt to get that back to us in writing, kind of put a drop dead date on that, and then we will rediscuss this on Thursday. Leland, you got anything to add to that procedure?
No, I definitely wanted to ask Michael and Jerry, obviously Brad, other lawyers in the room, when we looked in-house at this regulation, we did not see anything discrepant from the ordinary process of default in our world. And that's why we didn't think it was broken, okay? Because it corresponds to everything else going on outside. And I just wanted to make sure that everyone agreed with that. You guys think that's true?
And in Jerry's case, for the power sports side, and Jason, you know, the power sports dealership, there is no mirrored regulation. Why, I don't know. I mean, we've been in the power sports regulation now for 10, 12 years. Maybe it's just an oversight, but when we get into this, we see that on the motor V side, there is something, in the power sports side, there's not. So I think our proposal proposal is that we probably need to write a rule for the power sports side that would mirror the motor V side.
What do you currently do, Bruce, in the absence of the regulation? Is the statute satisfactory on its face to give you enough procedural latitude to handle it that way?
On the power sports side, I don't think so.
I wasn't talking about whether, let me rephrase that. In the absence of it, are you handling that way whether or not you've come to the conclusion that you have the statutory authority?
Well, let me first say by this, on this particular issue, I don't know that we've ever had a power sports.
I know,
issue.
I've never had, that's why I wasn't aware, because I've never had a deal of contact.
So we haven't had to cross
on
that
a
bridge.
default judgment.
So we haven't had to cross that bridge, but.
Oh, okay, well, that's easy.
If we did.
How simple can that be?
If we did, how would we proceed? It's a great question. Don't know.
Well, if it pops up between now and before the rule's promulgated, which hopefully it won't happen, that's a little bit what I was just trying to get at, because we do have some time here in the rulemaking process.
Right.
So that's the only reason I asked the question. Other than that, there's no reason not to parallel it.
Okay.
I just have a quick question. Does this meet the standards of all the regs that we need to look at and satisfy the tests that the governor has put forth to reviewing all these? Does this, do we get to mark this as one?
Yes.
Okay.
You get to mark if there was a discussion and there was an agreement that no modification needs to happen. So we would do that if there's no modification need to happen on the motor V side, we would do that, but on the power sports side, we would still just draft a regulation.
Yeah.
Okay, thanks.
Ma'am, you just came into the room. Do you want to be part of this discussion, or are you just a public member? So, thank you. Okay, so let's move to the next one, which is 12.6.105.1B. This is motor vehicle regulation, delegation of authority to the executive secretary. So this is 105.1B. Powers and duties of the executive secretary. And Mr. Dahlman, I think this is the one that you,
Right.
and I had a real brief discussion out there about. What we did is there were a couple little issues here that we thought that we don't think it's necessarily broken, but we think there is a couple of wording things here that are problematic. My notice says we may need to do some rewording on a couple of matters, so I'll just open this for discussion, including staff jump into on this discussion. So if you want to lead that discussion.
I haven't tracked it exactly with the existing reg to see what the changes are. Leland, can you educate us as to what was changed from the current reg to what's in this?
This is your current reg.
Okay, so there's no changes in it?
No.
Okay, all right. My only concern is I think the current executive secretary is exceptionally fair-minded, accessible, objective, and what else? What other adjectives should I throw in there?
Pretty handsome.
I won't go there, sorry. And there really aren't any problems with how this regulation has been exercised during your tenure in that position, Mr. Zuloff. But our concern is this is a lot of power, particularly the power to set the agenda and the power to conduct informal fact-finding on a license app. And we have some concern that, yes, although the current executive secretary is very fair-minded and exercises appropriate amount of discretion in exercising his authority under this regulation, that may change with a different executive secretary. I don't know how to go about limiting that discretion, but for instance, just to give you one example, the power to set the agenda for the board is the ultimate power. Because if somebody has something they want to bring to the board's attention and it doesn't get on the agenda, it doesn't get to the board's attention. And, you know, we've never had a problem with that with you, and so, but that is a fairly significant authority. And I understand the need for that. I understand that you gotta have an agenda for the board to control the time the board meets and considers issues. But again, there was some concern with this one as to the broad grant of discretion to the executive secretary.
In setting the agenda, one of the things that I mean, you are correct. I do set the agenda, and I have listened to outside interests sometimes when they want something agenda. And the only thing that I think maybe that we have disagreed on is the timing of it, but I think we've always got it there. But if somebody really wants something that's kind of off the wall, and I would say, no, I'm not going to do that, you know, that person or that group of people would always have the ability in public comment to make a public comment and ask the board that it be agended, and the board then could order that it be placed on the agenda at another meeting. So there is a way to have that done outside of the executive secretary. Now, one of the things I'm looking at...
That's a good point, Bruce, thanks. I hadn't thought of that.
One of the things I'm looking at here, and help me, Brad Leland, other staff that's brought your statute book, we have this as current regulation as 12.6.105 1B. 105 got changed in sunset. And so currently, at a minimum, even if we kept it all the same, there has to be a renumbering of it, because now 105 has to do with the creation of the auto industry division as a statutory created division. And I don't think in the current 105 there is any mention of the executive secretary position. Am I correct?
I was talking with Brad earlier, because some of these things changed as a result of sunset.
So I'm certain that the duties of the executive secretary statutorily are someplace currently still in the statute, but they're no longer are in 105.
It's still there, I think.
We need to find it, though, where the statutory authority is.
It's not in 105.
It's not in 105. The authority still exists.
Leland, question. How long has this reg been on?
Very long time.
So just historically, Michael, and maybe you're not aware of this, the executive secretary and the director used to be two different people. And in 1979 or 1980, they were merged. And yes, as long as you have people of integrity who are wearing that hat, as you mentioned Bruce does, you know, it's pretty clean. But if somebody is not, then it potentially creates a conflict.
If I may just interject a point of kind of governmental policy, most of the time, government cannot operate on the principle that someone will abuse authority. Because if you start with that idea, you will so restrict the executive in its actions that you'll have virtually no action. And, you know, that doesn't work. You know, the trick is, what are the checks and balances? What does the system permit to anyone who's an outsider who may be aggrieved to take up an opportunity to address that grievance? And of course, that's why we have supervisors of people like Bruce, all the way, his line of supervision ends at the governor, okay? So all the way up that line, there's the potential to step in to any process where there's abuse occurring. The board is the same thing. Their line of authority goes right to the governor. So obviously, it's very easy to write a letter to the governor if you think there's an abuse there. Likewise, any of the rest of us who function under either the board or actually all be under Bruce and the rest of us, we're obviously going to upline through him through that chain. Okay, so there's a supervisory level that's addressable. Then you have the checks and balances of the judiciary. There's absolutely nothing that says that a executive will be unchecked if he's given some discretion to operate. If he does something wrong, he can be brought to court. Bruce can be sued. So the offending party years ago before Bruce, who the allegations went had exceeded his authority in the prosecution of cases in particular. Okay, that individual, some of you may remember, actually went through a public dressing down in the press, among other places, and ultimately went through a supervisory removal process. We've seen this exercised again and again in every agency in the state of Colorado. So when someone delegates authority, they do so because there's an efficiency, for the most part. And this is one of those, and, to the degree that someone has a voice, like the voice in the agenda, Michael, okay, that voice can come through various ways. I mean, even if it's at the end of the meeting and you stand up and raise your hand and say, by the way, did anyone think about this might be an agenda item? There's ways to do it. But we have to be awfully careful, would be my admonition, in restricting the power. The exercise of the power, you have to try to restrict if it's badly exercised. That's all.
I would suggest the statutory authority is under 104.3A and 105.2B. That's where the executive secretary is mentioned in the current statute.
I'd agree with that.
Yeah, I think that's where I found it under. I think I've got it right because Chris agrees.
So if we continue with a regulation, even
Under
if we
either of those
modify it, we
sections.
need to just renumber it under the current
Right.
regulatory scheme.
Right, I agree. And I appreciate your thoughts on that, Leland. That, I certainly think there are people who signed the Declaration of Independence who might disagree with you, but we're not going to get into a huge constitutional argument about checks and balances. And as I said, this regulation has worked very well during the tenure of the current executive secretary. There are some potential issues. Mr. Perkins mentioned the fact that back in the day, that was certainly before I was here practicing law, the executive secretary and the executive director of the auto industry division were different people and wore different hats. And now those positions have merged. And there are certainly some potential problems with doing that. Not that I've seen them, but this regulation, with its broad grant of authority, does concern me somewhat.
Let me point out the current regulation. One of the issues that I guess I didn't realize was there, but it is there, and I have a little concern that it is too narrow if we move forward with allowing the executive secretary to do this per the regulation. And it has to do with in the current regulation, paragraph 3. The executive secretary is delegated authority to conduct informal fact-finding conferences and make recommendations for the granting or denying of an application for a motor vehicle salesperson license. Well, obviously, we have fact-finding conferences that are done by the BIT team, and those are sort of subdelegated in a way, because if the BIT team gets the application and it's not a pristine application and they need more information, that's part of the background. And so you could say it's subdelegated under that for them to ask for more information. But the bottom line is, occasionally, and I use this rarely, but I do use this, that I will make a recommendation to the board at a board meeting. They don't have to take the recommendation, but I will make a recommendation to the board respective to either granting or denying the license. But it says salesperson license, and I think that's too narrow, because I think that if we're going to allow the executive secretary to make a recommendation, it should be on all licenses.
Used in motor vehicle.
And so,
Yes.
yes. And ultimately, that in no way undermines the board, because the board has the final authority. It's just they get a voice from somebody else that they can consider.
You used a term I'm not familiar with, Bruce, BIT team, what's BIT?
Background investigation
Team, okay.
Our acronym.
Okay, and so if you're doing an investigation on a license, whether it's a salesperson or a dealer license, I assume your team reaches out to the applicant and asks questions and does that sort of fact gathering that I would assume they would do, and they prepare those reports which you review before the application is presented to the board. Is that fairly accurate as to what happens?
That's pretty close. It really is fairly accurate. So what happens is, like I said, if a pristine application comes in and everything is there, and that happens once in a while, everything is there, and there really are no questions that need to be answered, then the BIT team, either through delegation from the board in a delegation of authority document that the board, and I subdelegate that, we just issue the license. If there's any little red flags at all, then it's for them to have the ability to inquire further. You gave us this financial document, and it's just not exactly what the board requires. Here's what the board requires further of financials, those kinds of questions. And then, so what happens if there are, through delegation, we touched 22,000 licenses. We touched 22,000 transactions last year, licensing transactions. And so the board delegates to me through a formal delegation document that the board approves and spends quite a bit of time on the ability to issue those licenses. I use the word red flag if there's no red flags.
Right.
So we issue thousands of licenses that way. So what happens is when the background team, if there is a little bit of a red flag, Ms. Breeden weekly or every other week says, I've got 10 that I want to talk to you about that I'm just not sure about. So she comes in and we discuss it. And if I have 10, and that's probably after we discuss it, I say issue license. I go ahead and issue the license on 6 of them or something. I said, take these 4 to the board, because these are ones that I want the board to make a decision on.
Right.
So.
Does the informal fact finding that you do, does that become part of the record on that license that's available in discovery for an applicant who's denied, and can look at that and see what
Absolutely.
was part of the record? Okay.
And I think this particular regulation is beneficial to everybody, because the background investigation team can gather more information, which is beneficial to the board, which is also beneficial to the applicant. I think it just works for everyone. I think it just needs to be expanded to include the different license types,
Beyond
not just
salespeople and
salespeople.
dealer licenses as well.
Mhm.
Right.
Because the authority is under 12.6.105 2C, where it says the executive director, the director can issue or to refuse to issue any applicant any license the executive director is authorized to issue under this Part 1.
So what I'm going to point out on this one is I do think this needs to be modified to add those other
Any type of license.
Any type of license in 3. Now I'm going to open up a floodgate here, but I have to, because I have to do this because of, I want full transparency and full integrity on this, which the associations may have a little bit of a different opinion on, and that is in paragraph 1. The board permits the executive secretary to maintain the board's docket, grant motions for continuances, motions for enlargements of time, issue subpoenas, and issue final agency orders pursuant to the board's action. So the issue subpoenas, the power of the subpoena is delegated to the executive secretary in this regulation. Okay. Now there's been a change in law, because now in 105 the division director can now issue subpoenas. It's not worded this way, but just let me get to that paragraph. This is the new law.
How about 105.3, small case B?
Yeah, yes, sir, that's where it's at. Have the authority as delegated by the director to issue subpoenas. So that's a sub-delegation of which I can tell you I will never subdelegate that for the investigator on their own initiative to issue a subpoena. That was, if I used that statute, it would still come to me, and we wouldn't change the course of way we're doing business currently under the current regulation.
So you're recommending that we modify Roman numeral 1 to take that subpoena power out since you already have it under the statute?
I don't know if I'm making, I want to discuss that. I don't know if
Okay.
I'm making that recommendation. I want to think about that. Because now it would be in two places if the executive secretary and the division director are always the same person. It's in two different places, the ability to issue subpoenas. One is delegated by the board, the other one is the statute that allows the director to issue subpoenas. So I'm kind of open for discussion on that. Obviously, I'm going to argue hard that we, the division, either the division or the executive, doesn't lose that ability, because I think that's extremely valuable. But there's always some issues with subpoenas. I mean, sometimes dealers don't want to have a subpoena, they just want to turn over records. Other times they want a subpoena. We have non-licensed entities, for example, Carfax, they want a subpoena to protect themselves.
Right.
And so we do that as a matter of some certain financial institutions want a subpoena, so we do that. And right now we're doing it under this delegation, the regulation delegation. So that may bear some thought by everyone.
Well, and the other issue is if there's again a split between the executive secretary and the director of the auto industry division, if that ever should come about, then having the subpoena power in two places wouldn't make sense.
We're agreeing on a regular basis today, because I was going to say the same thing. Gloria and I have a lot of historical knowledge here, and it has been two separate jobs. It has been one job. It has been two separate jobs. It may,
Right.
it may revert back to that. The pendulum may swing back that way again.
Right. So if that should ever
Just a
happen.
question, when you were first on the board, were they two separate positions, or when you came on the board, was it? It was one. Okay. You just have knowledge that it was two before, yeah. I didn't remember what given.
I didn't think you were that old, Steve.
Sadly, yes.
That makes us really old, because we remember it both.
You got teenage interns then, right?
That's it, yes.
Yes.
So I guess my first blush would be to leave it alone, just add to paragraph 3. That would just be my first blush, but here again, after you all think about it, if you want to propose something differently.
I think where I would weigh in is the question out there would be, does the one authority conflict in any way with the other authority? So that it could create a potential, problem in a real world case. And I think everyone doesn't think that would be true so far. I mean, does anyone see a place that this would actually create conflict? Have both.
Depends which side of the issue I'm on.
Oh, okay, Michael. Be on your usual side.
I'm just being honest.
I know.
The devil's in the details.
Yeah.
It always is.
Right.
Is the reference 126104.3F2 still valid?
In paragraph 2 there?
Yes. Because if it's no longer valid, we need to update
Right.
that with the correct paragraph.
Which one?
In paragraph 2, we have a reference to 126104-3F2 with the sunset that may no longer be the correct
Right.
reference. And I don't know one way or the other, I'm just bringing it up.
Good question.
It's the same.
F2,
Yeah, it's-
yeah,
Is it? Okay.
it's fundamentally the same.
So we do have two statutory authorities here.
Anything more on that? Okay, so then let's look at the power sports, 126504-1B. And our staff notes it's probably the same issues as motor B, so it would be adding, it's kind of funny that the power sports regulation appears to be formatted slightly different than the motor V regulation, but I think the words are the same. I don't know that there's any difference in words, it's just a little bit of a formatting difference. So we would attempt, obviously, to format them the same, but I think the same issues would be in paragraph 3, is to add to the
Is the
dealer
Attorney
stuff.
General, is that referenced in here, or am I missing it? I apologize if I am.
Say again, Joe.
Where it talks about,
No, that's what's different, Jerry.
Yeah, there's no language to that.
Yes.
there is no language now, is that intentional?
Didn't you write this?
I was gonna say.
I didn't write, no. Leland, who reviews the rules in the
Yeah,
division here?
well, this is a good question, because if
Because
you,
I didn't see the AG scrutiny in this one.
yeah, if you didn't actually write this rule, I mean, honestly, Jerry, I don't know who did. Okay.
Yeah, this rule would have been written before
Yeah, long ago.
I was here, or right after the power sports legislation,
Right.
but, so obviously if all of the processes were being properly followed back then, doesn't matter who wrote the regulation, it would eventually go through AG scrutiny along with the.
Oh, I wasn't talking about what has taken place in the past, I was just saying, pointing out that you ought to make it conform, make it conform to the motor vehicle side, that's all. I wasn't questioning the previous
Okay,
process.
The format, yeah.
I don't want the court to throw out every single.
Okay, so again, 126105-1B and 126504-1B, if you have any further written comments, please get those to us, and we'll talk about when those will be due here in a minute.
And I checked both of the statutory 5041B is not changed and 126504-1F, Roman numeral 5 is accurate.
Okay, the next one we want to talk about is 126104-3I. I have to find that in my packet here. 126104-3I is a principal place of business regulation having to do with permanent sign, display of permanent sign 6 inches high, clearly visible to the major avenue of traffic, which sign should be clearly designate the name of the business for which the license application is made, under which the business is conducted. My notes were, when we talked about this, we don't think this is broken. We actually enforce this. Very rarely is there a problem coming before the board on this, but we enforce this. We go out and say, you've got to conform with this. Now, this is 2017, soon to be 2018. And both of you are motor vehicle boards and commissions with us, and this is one of those business practices that is really on the page. I mean, with internet businesses, currently principal place of business, you have to have brick and mortar, and you have to have a place to display at least one vehicle, and therefore the requirements of this signage is there. But is the industry changing so fast? Maybe not for the purposes of looking at this regulation at this point in time, but the industry is changing for us so fast that the industry is going to run by this regulation at some point in time because of the internet.
Is permanent signage, what's the clear picture on what is permanent signage and what is not?
Don't know that that's ever been defined, or we have attempted to
So
define
basically, the
that.
board and everyone sort of takes a look at it and determines at that point whether they feel that the signage is of a permanent nature or not?
Correct. And I think we have used discretion on this. We've never really, if you have a sign that is properly done on poster board or something like that, displayed in a window that is visible, meets all the, is that good enough? And we've sort of said probably so. It doesn't necessarily have to be out front on, two posts and all those kinds of things.
I'm thinking if a manufacturer, there's something that came up, the gap between getting the permanent signage, Jason would know this much better than I do, is there ever a problem with their requiring new signage and you're temporarily having to put anything up that complies with the manufacturer's request?
There is requirements. Yes, there has been.
There has been, okay. That's what I thought, because I remember that I don't know if the auto dealers have any problem like that.
They do.
They do.
What we've seen is on newly opened businesses,
Yeah.
their permanent
That's
sign,
also
which
what I was
is
thinking of.
properly constructed in part of their business. A lot
Yeah.
of
That's
times
why I
what
asked
they'll do
about
is they'll
permanent
run
signage.
and have a great big
Banner.
banner that is kind of cool done. They'll hang that banner on their.
But that doesn't cause the investigators any problem. Okay. I didn't think it did, and I'm sure we don't have a power sports dealer that was ever addressed to, because there wasn't ever a complaint.
And we know how expensive those signs are and how long they take to get. So we are very, very lenient on that.
Okay.
If you've
Just
got
asking.
something that clearly identifies you, we're happy.
I don't get the opportunity to have as much experience as Mr. Donahue does.
Is the signage requirement in statute, or is this strictly regulation generated? Chris is shaking her head yes, so there's your answer.
It is in statute.
Yes.
It is in the statute. So, the thing is I don't think you have discretion to mess with that requirement. I agree that the industry is moving away from that, and we're headed toward virtual dealerships.
So we may have to have statutory change.
Yeah, and then you're gonna have to have a statutory change to make that happen, because right now, you're required to have a physical location, bricks and mortar, with one flush toilet and a permanent sign. That's it. The one thing I wondered about is how you square this clearly visible to a major avenue of traffic with Boulder's regulations. Because I drive around Boulder looking for businesses all the time, and I can never find them, because they don't have signs out on the street. They're always back in the back, and they're small, and
If we have an issue, that is exactly the issue we have.
That comes up.
It's not visible to the public, and so
So
we.
who trumps whom in that situation? What do you do with the local ordinance that's in conflict?
It's a good question. I don't know that we've ever had that.
Okay, I
don't
keep
know
asking
that we've
questions
ever
about
had-
stuff you don't have problems
But
with.
we have had signage that wasn't visible from the major thoroughfare, and we work with that dealership to come into compliance.
Well, I remember Fay Myers and Greenwood Village, and that was a never-ending battle.
It's still
with the
ongoing.
planning commission about the signage, which direction it points.
It's
So
still
everything else.
That's still ongoing.
Is that still ongoing? That's only been 13 years, so I guess it's 14 years.
That used to be.
But that's why I really asked the question, because some of these jurisdictions like Greenwood Village, I'm sure Parker's the same way, Boulder you mentioned is probably, I'm sure those three jurisdictions are problematic in paralleling with the state.
I think what we've done there is we've exercised extreme discretion on those kinds of things, because this is, we want everybody to be in compliance, but this is a violation. This is not the crime of the century, obviously. So
Mike, excuse me, is it worth clarifying that? Or
I
should you
can't
just
answer
leave
that.
it as an open-ended question?
I can't answer that for you, Jerry.
No, I just wondered if you had an opinion on it.
I don't.
Okay.
I have an opinion that may not be the right opinion. But let me just tell you guys, as you were buzzing about this topic, and all of a sudden I realized this could implicate E05. Okay, if we are looking at something that's a mandate that in some way overpowers or could overpower a local entity's law or regulation, then we have to go through a whole different process on this. And
That's
we
why,
would have
by the
to-
way, that's why I asked the question
Yeah,
for the very reason.
Jerry, you're very perceptive. This would be a serious issue. So my question to those of you literally who have dealt with this, whether it's Jason or you or Mike or whoever in the past, okay, have the entities involved, have the businesses involved sought to resolve it through some court process in order to get a declaration of which is superior?
Mhm.
And what's been the result?
You'd have to get a declaratory order as to who trumps whom, right?
Well, if it's not been done, the question
Right,
is,
yeah. Somebody's gonna have to interpret the law, aren't they?
right, but that's the real issue here, is how do
And the
you...
board can't. Not in this case, I don't think. Because we're talking about
No.
statutes
I don't
and
think so.
ordinances, local ordinances. So I think you're right. That's where it would have to go. I don't know if that's a problem. Once again, does that come up? But it could. It certainly could, especially with so many jurisdictions.
It absolutely could. It's never come to that level yet, but I can see it happening.
Yeah.
Let me ask a related question. When you get a dealer license application, do you check the zoning where that dealership is proposed to make sure that the zoning permits the dealership to go into that
No, the application tells the applicant to check it.
and verify that it is permitted under zoning?
If they're going into something that looks really questionable, then we may look at it and tell them, doesn't look like you meet it,
So-
and then they'll get something.
They just make an
Notify the
affirmation on the
Okay.
application.
Have you ever denied an application because zoning didn't permit the dealership at that location?
No.
Yeah.
Okay.
That's interesting.
I don't know if we ever denied an application, but we had an issue with an application.
Well, that was Boulder with the chemical toilet. Was
Boulder and the chemical toilet. Chemical toilet is not,
A flush toilet.
didn't meet the regulation, and also there was a zoning issue there where Boulder eventually, I think, required him to move his location. If
Okay.
I remember right. That's been
Boulder required it, though. The dealer board did not require
Okay.
it.
70 years
Just make
ago.
that
But
clear.
is the city,
I was just curious about that issue, sorry.
yeah, no,
And I got off.
that's a good point, because it made me think about the fact that what's likely to change is signing ordinance, rather than the state, the board, trying to fool around with it or go to the General Assembly and try to get something nailed down. So the one thing is, I think that's great that you do look at that upon initial application. I was thinking actually a little bit more about after the initial application, and then, because you're not revisiting it on a regular basis, and you wouldn't have any reason to, am I correct?
The only time it's come up is when code enforcement sends us a complaint where they found somebody who is not in compliance.
I just wondered what happens if they change the ordinance. Because I mean, that's been changed on a regular basis,
Well, it's
hasn't it?
changed
Don't
all the
don't the municipalities?
Cities change it constantly.
Pardon me?
Yeah, cities change it constantly.
Yeah, that's the point I was getting at. If this was a one-time change, it wouldn't be so bad. But some of these cities, municipalities, change those ordinances depending on who's they have two people change on the town, on the council, and a whole new sign ordinance comes out.
It's changed 3 times.
And I don't know,
It
is
doesn't
that?
affect signs that are already in place, it affects going forward, right?
I don't know, is
Doesn't
that the
affect
kind of thing to
existing
be applied
signs.
Well, it
retroactively?
does not affect existing signs, but if you go to do anything within the city, it may become a
Change,
topic of
yeah.
discussion.
Yeah, okay.
So,
That answers
Mike,
it.
from a used motor vehicle dealer who's more inclined to move on a regular basis than the franchise dealer who's got a territory that they're gonna set in place. We as independents or used motor vehicle dealers who have moved a bunch, it's always a big criteria first to identify zoning and signage requirements, whether you even want to sign a lease within that jurisdiction, because if after the fact that there's a complaint that comes up, then you're trying to break a lease or get out of a lease and take down your sign that is illegal. So
What I'm going at
affects
is,
the-
yeah, but what I'm going at is how much can the board lean on the local municipality?
oh, yeah.
That's really what it boils down to ultimately, if you do come into conflict.
So here's the key question for especially the attorneys, but the key question is, I mean, we don't think this is broken. Right
Oh, I'm
now.
not suggesting, but
But should we attempt to leave it the same until it's challenged for those issues, and then deal with the challenge? Because I think.
oh, no, I'm not, and frankly, I don't know that the degree that the AG's office and Leland would determine after looking at the law exactly how you would do that
Yeah.
and what language you would use. Seems to me probably to do it right, I think I'd want some clear direction from the General Assembly. Because ultimately, conflict of laws and so forth is going to be one of those issues that you would look more towards the General Assembly to resolve than you would local government.
And I agree with Leland's issue that if we do take this forward and propose any changes to it, do we have to cast a broader net under EO5? I think we might have to if there's any changes to this. I agree with you, Leland.
Mhm. Well, that's why I'm not even suggesting that you change this regulation, because I'm not even sure that that would do it, is what I'm saying.
So move forward as is until there's a requirement.
You can tell I've had a lot of experience with signs in local municipalities. Huh?
So in 1989, we signed a lease to move into space 6th in Indiana. Fortunately, the lease had a provision that said if we're in violation of any governmental agency that we can break the lease. We entered into that agreement, and only after the fact did we find out that we could not put a permanent sign on the monument because the building owner didn't provide for that. And so we were allowed to exercise the escape clause from that lease because we could not put a permanent sign on a monument sign outside that building. So
It seems case by case.
Yeah.
Because it happens so infrequently. I mean, there hasn't been any issues at this point.
All right, so let's
Although I
move.
bet you there are conflicts.
yeah.
I guarantee you, and I can guarantee you there's more than one.
Yeah.
So the power sports part of that, there's the same regulations, so we would treat it the same as. Okay, I have to do about a 5-minute stop here from me. I'm going to ask Chris to continue with the discussion on the next two. I'll be back in about 5 minutes. I got to put together sort of an emergency thing for a
Should we
courier.
just take a 5-minute break?
Let's just take a break.
If you're ready to do that, that's.
Yeah, let's do that. Yeah, John needs more coffee. It's a need. And I brought you sugar. It's not mine.
It's been a couple of years.
I don't know how I caught it. Physical pot base. Drag it. It broke the opposite way that most heels break. Let's put it that way.
Oh, you know what? I went to the general mailbox and I used this specifically. You know what? I will forward it to you as soon as I get back. And this is, you know, they were in Boulder. We were just talking about Boulder. Science, and that's one of the dealerships like I never find up there. They opened a new location somewhere else I've never not been to. It's now, and they changed the name to Flatiron.
Right.
And I talked to them about being an additional location or a new dealership, and they elected to go the new dealership route. But they're owned by
Yeah,
Holman,
that's fine.
which is that big.
It's nice to see you.
Howard said. Yeah, there's a huge, anyway, I will find a package and forward it to you as soon as I get back to the office this afternoon.
No, I
Thanks,
understand.
Corey, I appreciate it.
No, I know you've had other stuff. What do you think so far? It hasn't. I mean, other than, is the time been an issue? No.
Except for a lot of things that move.
Yeah.
Jason, I never got your expense report. Did you sign it? You won't get a stipend.
More importantly, you won't get a check.
Did you
Do you
put
have
it
a
in?
blank
Did
No.
you put it in your bag or something?
I took notes on it, took it with me.
I'll take it. Well, what we could do is make a copy. Plus, this is for you to sign, Jason. Do I have
I
to
know
put
that.
stickies on yours?
Don't mess with Arlene, Jason.
Believe me, I've
And
learned.
you're learning the hard way, it sounds like. She's threatening to put stickies on stuff for you.
I want to tell you, when you got Don removed in front of you, please give him a hard time.
Yeah, give me a hard
I
time.
really
I
appreciate
deserve it.
'Cause
Jerry, you ask the best questions. You need to bring a lawyer with you to these meetings. I'm all about the Full Employment for Lawyers Act, so.
Well, I mean, I thought that was a great one.
It wasn't good. No, I'm
If you're a zoning
sincere.
attorney?
I'm sincere. And you asked me, and I'm not gonna state an opinion on the record, but since we're off the record, I think the local municipal zoning would take precedence over a board regulation.
That's my question.
That's my
Because
opinion.
I think you could make it clear in the statute, though, unless it's a constitutional matter. I don't know in a home rule city how that, you see, and I assume that plays into it.
That's my opinion, shooting from the hip without doing any research.
Yeah, exactly.
Which you cannot rely on in any court of law.
Don't bring up home rule, that just
I know what
terrifies.
that does, here, folks. I know what that does at the state level.
Home rule always wins, always trumps, right? We know
Well, what
that.
about if it's a county ordinance?
They're a home
Then don't we get into those
They're
weird
a home
county
rule
powers?
entity too.
I know.
Then you gotta go look back when it was created.
Well, I do a job as well as you do, which I'm not a practicing attorney here in this state. But I do like to ask questions.
I know you do. You ask good questions too. Questions that there are no clear answers to.
Yeah, that's why I
That's the
guess
kind of
I asked.
lawyers like
It's like
best.
a law school exam, remember
That's
those?
the kind of lawyers like best.
Yeah, ambiguity is their friend. Let's face it, ambiguity is an attorney's friend, depending on which side of the fence they're on. I always like to do some of those things that I know there's really no clear answer, because I always want to see what Bruce says.
Yes, yes.
That's just cruel.
It's just a
Uh-huh.
test.
It's
Cruel.
just cruel.
Just a test.
Well, if I can get him to return my phone calls once in a while, I don't think I'd trust him.
Fay Myers is not in Greenwood Village, are they?
They are.
Are they really?
They're the worst to work with too.
They are.
They could be worse than Bolton.
You should have seen when we had to relocate, when the place burned down downtown. That is one of the biggest, I spent literally a year on nothing but dealing with Greenwood Village, the inspectors, the ordinances, everything. But I got and South Metro Fire, they take the strictest national form of the fire code, and they bump it by 20% when it comes to percentages. So for example, flow for things like sprinkler systems, water curtains, that kind of thing, it's already beyond actual recommended needs of any code out there, and they bumped it. And you know, how the hell are you gonna meet that? You know how you meet it? You go out there and you spend $250,000 to bring new pipe in underneath the street, so you can get 2 more gallons per hour. That's what, I mean, it was unbelievable. It was enough to drive me out of my, finally, we agreed upon curtains.
Yeah.
That we could get some extra flow in the one part of the building by adding 84 more sprinklers in that area in lieu of additional flow, which of course should be more than satisfactory.
They must have paved the way for Cooney Lexus.
You
'cause I
gotta
thought
really,
it
to
was-
appreciate this, you really gotta be in this business for a while, don't you? To sort of really appreciate what it does to your brain.
He must have paved the way for Cootie Lexus, because I thought Cootie was the first dealer in Greenwood Village.
Well, you know, everything else just to this, you know, Shane, that street, now that's where Centennial starts.
Right.
So I think maybe all but one auto dealer is in Centennial?
Yeah, or it used to be a.
Are we going?
We're recording.
So we're back on the record after a short break. So now we're going to look at 12.6.115.6 motor vehicle regulations, substitute service of process. One, 12.6.115.6. Slide, this is a regulation, licensing to serve with process. Upon the Secretary of the Board of Secretary, no later than 2 days after the service of said process, upon him or her, mail a copy of each license address to the last known address furnished by the board licensee by certified mail with the request to return. So the copy shall also be mailed to the surety on the license bond at the address of surety given in said bond by certified mail with request for return received. When the staff looked at this, we said that we don't think it's broken. The only question we had was the 2 days. Is that?
Quick question. You almost always, in these discussions, sort of formally close out the discussion on any regulation we're talking about. Did you formally close the discussion on signage?
No.
Would you, I'm just mentioning if you
For the
might-
record, okay.
Yeah, for the record.
I'm sorry, yes, so the same kind of caveat is that if any of the members of this group want to weigh in with either the signage regulations, please do so in writing if you have that, so.
I'd like to file a formal complaint against Mr. Abood for the unauthorized practice of law.
Where's the client? Can you see the client here? I'm sorry. Would you like to look at my client list? I don't have it. I do it all the time now.
I know you do.
Assembly. Well, am I that bad?
No, you're
Okay.
fine, Jared.
No, I was.
I'm just giving you a hard time.
I'm adequate for what I have to do.
Okay, so I don't remember, we had a discussion, the division had a discussion, we didn't think this was broken. I don't know how much we used this, have we, if ever. And so, because we never used it, I guess it would be sort of our opinion that maybe just leave it alone. The only question would be the 2 days, if it's worth looking at the 2 days and changing that, and I don't know.
The only issue I'd see if it comes in on a Friday, it doesn't say business days.
Yeah.
So you'd have to get it out by, so I would recommend kicking it back. But, the times I've sued bonding companies and licensed dealers, I've always just served the bonding company who has a registered agent in the state. I've not availed myself of this provision.
And the thing that's always seemed odd to me in all the years that I've been here is the statute talks about, agent per service or process, blah, blah, blah. This regulation is more of a regulation on the division than it is on the regulated community. So it never quite made sense to me, its existence at all. And I don't know that we've ever really had to utilize it. I don't think there's ever been any issues. So I don't know that it's broken, but I don't know that it needs to exist, I guess is what I'm trying to say.
Anybody have a hard opinion whether or not we should just do away with it or not, or just leave it alone? First blush, this is just first blush, knowing that.
Well, I think the fact that there's a statutory provision that someone may avail themselves at some point in time where you may get a summons and complaint against a bonding company where the attorney serving it on you says, I'm serving this on you on behalf of 12.6.115, open parent, 6, closed parent, then you've got to know what to do with that. And to have a regulation in place isn't a bad idea. But, Yeah, I tend to agree with Chris. If it's never used, do we really need it?
All right, so here again, hearing nothing, at least at this point in time, same issue, we'll just kind of close that on, and the power sports side would be the same exact issues if there is an issue. So I'll close out the discussion on those two with the same caveat. If you have any different concerns over the next few days, we'll see that in writing. The next one is number 9. And this one is broken. And this, I'm glad that I'm really glad that Jerry is here, because this was really the huge basis for the power sports law, because we had those dealers, especially in China, that were manufacturing less than reliable power sports vehicles, and there was no standards there. So not only did the statute bring them into under the authority of the board to regulate, but this regulation was written to further define the statute. The concern we really have, where we really think it's broken, is the last sentence, and that is the wording is such a certification label shall comply with the requirements of Section 12 of the ANSI SVIA's 1/2007 standard. And our question, Jerry, is should the wording be the current ANSI standard?
I would, because you know what they do? You may already know this, but the work I've done with SVIA, which is the industry representative that's worked with ANSI on this, is that 2010, there was a change made. So right now, we're sort of, it does mention a successor standard in the first paragraph. But I think that would be fine to clarify that, because they do, as a matter of course, formally revisit them about every 5 years, I believe. And then in the interim, if the Consumer Product Safety Commission has a problem with something, they're rewriting their regulations all the time. So I think that, to me, that's a good idea. And like I said, I did go back and check to see how many, call them amendments if you want, they call them revisions. But they made a revision, a very small revision in 2010. That's basically it, but you're correct. They do revisit them, and they do it reasonably, with some regularity.
So would it be appropriate for just you and Leland to have a conversation in the next 4 or 5 days to how to change that language? That language is less than.
I like working with Leland.
Yeah, because I agree, right now it does say we're successor,
Yeah, it does.
That's
I mean,
all
that's
well and good
why.
when there's only one successor. What happens when there's 5 successors?
Yeah,
Which
I mean,
successor
that
are you
language
talking
should have
about?
been, it probably should have been clearer than that. Yeah, and so that's why I'm with you 100%, and particularly since I know there's been a revision.
Well, the other thing that you have to look at too is that if something is built in 2000, okay, they have a successor one, so now we have a revision of 2010. If it was built before 2010, does it still have to comply with 2010 standards?
Yeah, actually, I think it's essentially a single document that is then revised. So I mean, I don't know how you would contemplate that, but that's how they do it. They don't, it's not then referred to as a complete new standard. It's just, but I understand exactly the point that you're making, and that would be a problem. I'm just suggesting how they, for purposes of notice to the public or manufacturers or anyone else who might be interested.
Well, and that's what we need to make sure it's clear for both sides of it, because the dealers need to understand that they're complying with the correct standard, and if the waters get too muddied, how can we enforce it, number one, and how can the dealers really know what they're supposed to do?
The federal government, about a year after we did this, the federal government passed a federal statute that required compliance with the ANSI standard. I don't know if you still need this. You've got a statute as a basis, but you may still need to.
Well, why don't you think about that, Jerry? Because this is
Okay, that's
truly
fine.
your baby.
And you obviously will review all this, so it's not a.
Getting into John's, I know exactly what you're saying. Rather than the current ANSI standard, should it be some kind of legal language that says the standard that was the ANSI standard that was in place at the time of manufacture.
You put like the ANSI standards as adopted from time to time or something?
I don't know how to write the language, but it does have to address that because, like I said, it's not fair to have somebody, when they change it again in 2012.
Well, I'm with you 100%. I was just kind of, I was thinking about our previous discussion. I don't know what the federal statute says, but you know, in this case, they probably say it could be stricter, but not less so. I don't know,
So
but
if
you can still prosecute them, can't you? I shouldn't say- I use the word prosecute loosely.
Maybe.
Well, first of all, you're never going to find a Chinese manufacturer in the United States, so I wish you a lot of luck on that one. You will need an international law expert to track down. So anyway, yeah, that's fine. I'll be happy. And that's it.
Just,
We'll take care.
just for the record, Brad just pointed out to me that the statute itself that we're looking to has some very much better language than the rule does. So, you know, we have a lot to work from. And then the other thing that I would point out is that the guidelines that the OLLS sets also have language that is acceptable for things in continuation. And then the other problem is that anytime you incorporate industry standards and you have a floating document and you get too specific, you end up sometimes, like here in this reg, it says section 12 of a standard. Well, that's one of those, like, can you change paragraph numbers easily?
Sure.
Yeah. And so, you know, what will probably come out of this will be something that is sufficiently generic to match the statute, that incorporates anything that the federal law might force us to think about so we don't conflict, and that also goes to whatever the heart of the document is that we're talking about. So it'll probably be just fine.
Okay, so if the two of you can kind of have a conversation after.
I already paid for this, dude.
After a few days, oh yeah.
By the state.
Yeah, it's,
Yeah, okay, Jared.
it's $1 a day.
When I get my lobster, you get okay.
So I'm going to close that out with that, kind of that caveat that Mr. Green and Mr. Beebe will work on. Just a little clarification to this, no major change, just clarification. Okay. Now for the biggie. This is the biggie. First of all, just know that Regulation 12.6.102.16 has to be renumbered because this definition, this is a regulation to a definition that the number has changed. So we know that, okay? The statute didn't change, but the number did, okay? So now we get into, this regulation has 3 or 4 different components to it. And I will tell you that the AG's office, number 1 is general counsel, past general counsel, just so you know, Brad, you're just going to have to ask over there about what the sort of stance of the AG's office is, but there was always concerns that this regulation attached to a definition. So if there's a violation of this regulation, can you charge a definition? And that, I think there's a really difference of opinions. Attorneys have difference of opinions on that. There was a time that YE thought that this entire regulation was totally in the wrong place. It needed to be carved up and put in different places. But I think Leland's done a little research on one of the things, maybe that is not necessarily the case. But regardless of that, this regulation holds 2 or 3 really, there's 2 or 3 issues here that are always in kind of dispute. So let's just jump into this. The first paragraph talks about off-premise permit. The dealer shall obtain an off-premise permit to offer or display some motor vehicles away from the dealer's place of business. A request for an off-premise permit shall be made in writing prior to the event. and shall list the location, dates of sale, and permit shall be posted for inspection at the sale. Wow. Okay, so let me give you my perspective of the history of this. And I don't remember if you were still on the board, but if you weren't, it happened right after you were. So we have dealers that come in and get off-premise permits, and they set up their tent sale in the backyard of another dealership someplace. And the other dealership was running through the door and screaming, this is a violation of everything. They can't, they've got to sell from some location, not in my backyard. There was issues on the western slope with the dealership setting up sort of in the backyard of a franchise dealer. There was an issue in Craig where they set up in the backyard of a franchise dealer and they collected the wrong sales tax. The dealer said collected the wrong sales tax. This was heavily debated at the board in about 2010, roughly. At that time, the members of the board, including the used dealers, made a motion on the record to put a moratorium on all off-premise permits. Moratorium no longer would be allowed until they could look at legislative change. The Attorney General's office immediately came in and says, no, you can't do that because that is restricting commerce and the board can't do that. Then there was discussions about changing the fee. The fee used to be, just off the top of my head, $115, and then they raised the fee, sort of a nominal fee, then they raised the fee to $300 or $400. But at that point in time, there was members of the board that wanted to, that didn't believe in off-premise permits, that didn't utilize off-premise permits, that wanted to raise the fee as much as $15,000 per permit. Okay? And that was debated. Then there was some debate that was generated primarily by me, and that was, should the board consider that you allow a dealership a certain number of off-premise permits? And you get 3, 4, use them wisely. After you use the 4th one, you're not going to get another one. That was debated. Okay. Then there was, what am I missing? There was debate on, there's one other major issue.
Tiers.
Well, that was
a suggestion.
That was a suggestion. Right. The debate. Right. There was one other.
There was another debate.
There was another example.
Around one used motor vehicle dealer getting an off-premise permit for the location of a second used motor vehicle dealer, and they had a combined inventory thing, and nobody knew who was buying from who.
The cross-inventory agreement.
This was a dealer. This was a used dealer within a used dealer.
Oh, okay.
Yeah.
The one, then the other issue that was the master consignment agreement, which we've got 3 conglomerate dealers that have decided that they were going to a franchise Ford, a franchise Chrysler, and a franchise Chevy, and a franchise Kia, all owned by the same ownership group, would go together and get off-premise permits for all 4, and they would come together in the same location and have a tent sale, so to speak, in the same location, and they would do a master consignment agreement where the salespersons now currently have to be licensed at all dealers, but they would not do that. They would do this consignment agreement, so they were consigning vehicles back and forth to not meet the requirement of salespeople being licensed at every franchise, at every dealership. That was debated a lot. That, I think, is still going on, and I took a real hard stand on that, but eventually lost when I realized that, when I was told that the division in about 2002 or 3 allowed that to happen and said it was okay at a Sports Authority field event or Mile High Stadium event back in the early 2000s. So the division had to totally back off of that. So the history of this is very contentious, and it's very contentious by both franchise and used dealers, and It's very contentious, meaning that some franchise dealers love this regulation and some franchise dealers don't use it and hate it. And I know in talking with Tammy, it was one of those things that CAD was sort of caught in the middle on this a lot of times because the clients, were on both sides of this issue. So strictly for this, the suggestion was to come back in and do some kind of a tiered thing and maybe address in rulemaking whether or not a master consignment agreement is allowable in rule. So Tammy put together some rough language about tiering these. And so if you're truly having an off-premise tent sale, it's this tier. Let's just say it's tier 1. If the board approves that, there would be a substantial fee for that. That's what the board sort of indicated. Tier 2, what might be just some kind of a show where you're not moving a bunch of inventory, you're not attempting to do a tremendous amount of sales, you're attempting to build your customer base and still send them back over to the real store and all that. Tier 3 might be, and it's not something that we do now, but mall showings of things, cars in the mall showing of things. I'm going to let John talk about, I don't know what another tier would be, but the ambulance thing.
And trade shows.
Trade shows.
Trade shows. Yeah. Where we have ambulance, fire department, fire equipment coming together, and truly that's the only place that they sort of display their wares at that event, and they want that. They want something like that. So sort of on this issue, that's where we're at, is what do we do here? Because although we have not, in the last 18 months, had a complaint on this, boy, 3 or 4 years ago, we were getting beat up pretty hard on this. So open for debate at this point in time or for comment.
Can we require in the regulation that dealers who are having off-premise permits use unethical slasher out-of-state salespeople to conduct those off-premise sales?
Require.
It's kind of an unwritten requirement.
Gloria's rolling her eyes over there.
And Mr.
No, I'm only kidding, of course.
Actually
but-
brings up an issue that we had with the Southern Colorado dealership that properly got an off-premise permit, but turned the entire sale over to an Arkansas company that came into our lobby and got temporary licenses and had criminal histories like crazy, and it was a total mess, and went down and had the event. And of course, the problem with that is when you do that, they get a temporary license, and they're here for 3 or 4 days, and you don't even get the background investigation done. Changes now with the fingerprint, but you don't even get the background investigation, and they're gone.
Yeah.
So that was a real life example of one. So this, I think that this one really, I think there has to be change here. I think we need to debate this, and all sides, and try to come up with some kind of reasonable compromise that everybody is reasonably happy with, so.
Is there statutory authority to limit the number of off-premise permits?
No.
I wouldn't think.
Probably not.
So that probably does not work. Could you, in a regulation where a franchise dealer is concerned about somebody selling like product in his backyard, get something from that manufacturer allowing them to have this off-site sale, and said is there statutory authority to control that?
Manufacturers don't get involved in off-premise sale issues, and the problem with the backyard is it's very broadly defined, Steve, and virtually every inch of the state is assigned to some new motor vehicle dealer or another.
Right.
There are probably parts of the state that aren't, but particularly for like General Motors products.
Right.
You'll find that virtually every inch of the state is assigned to some dealer or another. So when somebody does an off-premise permit outside of their assigned territory, they're by definition in some other dealer's backyard.
Right. But I'm saying, can Denver Ford get a off-premise permit for Craig Colorado but can a regulation be written to require something from the manufacturer, giving them the approval to do so? We have the
Manufacturers don't-
statutory authority to put that in regulation.
You don't have authority over manufacturers.
Right.
The board.
The board does.
Yeah.
Right.
And as a practical matter, manufacturers aren't going to weigh in. They're not going to get
They're not
involved.
And Mike had another case, it was Mike's case, where we had a dealer in northern Colorado dealer get an off-premise permit right on the state line, and so the complaint came from a Cheyenne dealership that was infringing on his area because it was on the state line.
They were actually over the border, and the Wyoming regulators made them move all their cars on to Colorado and get them off that Wyoming property. So
They were over the line by only a couple feet.
that was.
Yeah. So that's sort of another example of what happened here.
Right.
Now,
We do have the authority to stagger fees based on.
Right.
Because the board can set fees.
Right.
So we do have that authority.
Well,
Well, you're gonna do it once a year, too.
yeah.
Right.
Yes and no. And here's yes, okay? But the no is that in 12.6.110, which is where the fee is, there is no fee for an off-premise, there's no fee in statute for an off-premise permit. So the way and the Attorney General's office raised that issue big time in 2009. You're charging for a fee that you don't have statutory authority to collect. The way we ended up getting around that is that it's an extension of their license. So I don't know if that would hold scrutiny at an appellate level or not, but that's the way we got around it. Okay.
Well, and the other thing, and I don't know, Mr. Dommermuth, you could probably answer this best of anybody in the room. Aren't there some franchise dealerships that are maybe in smaller, more rural communities that like to use the off-premise permits to come into a bigger metropolitan area to maybe generate some more sales?
Yep.
To meet their...
Get on the county fairgrounds, get in the mall parking lot. They think that it helps their sales, helps consumers, encourages competition. So, I'm squarely in the middle on this issue. There's things I like about them and things I don't like about them.
Well, and you have half your clientele, the
Likes them,
CADA's clientele, that is going to say, yes, we love off-premise permits. It gives us an opportunity to appeal to a broader audience. But then you're going to have some of the other dealers that go, hey, they're setting up their tent in my backyard. Somebody do something about this.
Right.
What's the
answer? And I don't have any good answers. I was just talking to Matthew. One thing that may help us avoid problems with these is to avoid the out-of-state salespeople coming in to run them. Require dealers who want to have off-premise permits to use their existing licensed salespeople to do the sales, and avoid these slashers coming into the state and creating problems. That's where the problems occur. That's where the consumer harm happens. Maybe against some of my clients' interest to say that, but that may be a good regulation to adopt in conjunction with the off-premise permits.
Marshall, I guess I would worry a great deal. We'd have to start with the research on that, because to me it sounds like a Commerce Clause violation. I mean, if you remember the Minnow cases and the mud flaps cases and things from law school, I mean, that sounds like it. It's an attempt to restrict interstate commerce. And there are very narrow provisions that permit that. I don't know whether we fit in one.
I think it'll be minimized with fingerprints, because somebody's not going to be able to fly in from Pennsylvania, walk in, get fingerprinted, get their application to us in time for sale.
So as a practical matter, John, you think we may already be there?
More than likely. I think there's going to be some exceptions, but I think the vast majority of those tent sale guys who come in, the logistics just aren't going to work.
Right.
Now, one of the things that, regardless of what the group decides, that the division is 1,000% going to dig our heels in, is these permits. We have to write a time frame into these permits, because what will happen is they walk in the door literally at 3 o'clock on Friday, and the sale starts on Saturday. And so they overwhelm us that way. And so we have no ability to look at, we issue the permit. Lots of times, they're out there practicing without a permit.
Yeah.
We go out and shut them down and make them come and get the permit. So I don't know what's reasonable. One time we thought 30 days in advance, and if you're outside the 30 day, you're not gonna get the permit. I don't know if that's reasonable or not, but just to throw out a time frame for debate.
Yeah. And I tend to agree with Leland. I don't think we have the authority to restrict to the salesperson already being licensed, but I think the board does have the authority to set some time frame in the issuance of the permit in the regulation. It's got to be 14 days in advance, so the division can do what they need to do.
To
I think that's
make
clear.
sure people have the background they need.
Yeah.
A couple of things I noted in here, and these are, I think, more addressed to Leland. The Metro Denver Auto Dealer Association no longer owns the Denver Auto Show. It's the Colorado Automobile Dealers Association, Leland. And then that last sentence in subpart 2, rather than saying consecutive permits for the same location are not allowed, I would just say change not allowed to prohibited. I think that's a little clearer language. So.
And one time, I know that Tammy wanted to change the wording and/or define consecutive.
Right.
So.
Right. Do you have you mentioned Tammy's proposal on the tiered, and I remember seeing that at one point in time. Can we get that copy
I've got 'em.
distributed? Thanks, Lena. If you would shoot me an email with that, and
Some of what
that may
she-
be a good place to start.
Because I think some of the work she did, not all of it, because I will tell you, I'm not sure I agreed with all of it, but a lot of it was pretty well done.
Yeah,
So,
good.
No, you started from scratch.
Right, exactly, and that's what I'm thinking too.
So number 1 and number 2 sort of go hand in hand, but they're actually two separate issues, but they go hand in hand. And I think no matter what we do, they sort of have to travel together.
Right.
Okay.
And it seems to me they'll go under subpart 23 now.
Yes.
That's the principal place of business section now. And this seems to be an adjunct of the principal place of business.
So here's what I anticipate, and we can discuss this more if we need to right now, but I anticipate that when we really get to next week, next Thursday, and look at this and start drafting things, at a minimum when we get to public hearing, this could be an issue, because when you notice a public hearing, you could have lots of dealers come in that are on both sides of this to give testimony for the board. I don't think this is going to be an easy one.
Right.
This is going to be a difficult one.
Wondering if it makes sense to have a third stakeholders meeting on it before we take it to the board.
It may, and just so everybody, we had this agenda last year, and we spent so much time on the material particular thing that we actually had some good discussion on this one, but I didn't think we could do them both at the same time. So I pulled the off-premise off and said, we're going to do that at another time. So now I've added 10 things on instead of just one.
Right.
Thanks.
But the 10 things don't seem to be, too much controversy. This one will. This one very much will. And there's all kinds of issues around this. Do you charge a different fee for a different tier?
Well, defining the tiers would be a nightmare for us enforcement-wise.
Yeah, you need a secret decoder ring to figure out, is this a trade show, is this
Right.
this, is this that, And our licensing staff, if somebody does come in and says, this is what's going on, are they gonna be able to make an informed decision with very clear lines as to, oh, this is a tier 1 or this is a tier 3, to charge the correct fee?
Right.
It is possible that, especially the franchise dealers that don't like this, might come through the door with a request that this fee is extremely high, like they did last time. We had 2 board members that, $15,000.
Well, I know there were a couple ambulance companies that really hurt them, because there's 2 big trade shows that they try to go to every year, And even at $500, it made it not cost effective for them to go to those trade shows and try to sell ambulances. So there's two sides to this. I mean, there's really some small dealers that this affects disproportionately.
Well, and from the new motor vehicle dealer standpoint, the factories require such a substantial investment in facility. And then for the dealer to make that investment and then turn around and have a competing dealer set up in their backyard without having made that same return on investment or investment in their facility, then they're going to really be at a disadvantage. So I can certainly understand why dealers would not like off-premise, new motor vehicles would not like off-premise permits.
And Mike and Matthew, just so you know too, Tammy did some research over the course of the last couple of years, nationwide research about how many states allow this and sort of what in general the parameters. So that research is out there. It's probably in your database someplace. We may have that too, but that's a nice starting place to see if that's happened. I think a lot of states do something like this. I know South Carolina does, at least a couple of years ago, allowed nothing. You couldn't even display a car at the supermarket. It was your principal place of business. That's where you're licensed. That's where you're going to do business. And I don't know that. I'm not suggesting that we try to ever get to there, but at the same time, it's kind of different from state to state too. And that research she did quite a bit of research on that.
And that is a thing that is kind of the threshold legal question of, well, first of all, it's not written in the statute anything called off-premise permits. But assuming that we can have such a thing under the statute, which we've assumed for decades, do we have to? I mean, there were proposals back in the discussions in the history of the board to just have none. Forget this. This is just something beyond what we absolutely need to do. And so then that's the question right up front. Do we want to have it? If we do want to have it, do we want to have what we have now? Or how do we want to change it?
And you're going to have the automations of the world and the Phil-Longs of the world that like these, that they're going to come in the door and say, what are you doing? So.
Well, and you have some power sports dealers that go to the flea market on a regular basis. You have, you have a lot of events that, I think that the majority of the used car industry, and tell me if I'm wrong, Mr. Perkins, are probably a little more supportive of off-premise permits because they tend to utilize them a lot.
The independents do? How many have we issued this, well, of course, we just started a new year. How many off-premise permits did we issue last year?
I could run a report.
Well, we don't have to run a report. It's in our annual report. I just don't have it in front of me.
Yeah, I could run a report for how much.
I could check that.
To me personally, with the big tent that's now called the internet, they're not as attractive as they used to be. You can easily shop for cars versus having to have a big tent sale to get to see hundreds of cars at one location. So I'm probably not a very good one to ask that question.
I don't know if the majority of the people that are going to come in and testify before the board one way or another. I mean, I think the new car folks are going to be split.
Right.
What are the used car? Trying to get a pulse for what the used car.
Helen, can you run into my office and at my desk, towards these windows here, there's a filing cabinet right there. On top of the filing cabinet is a one-page annual report, and it's got some yellow on it. It's an Excel spreadsheet. It's got some yellow on it. That's so I can answer that question, Mr. Perkins, how many we issued last year.
I do want to go back to, because I certainly am sympathetic to the franchise dealer and the territory, and I understand that we don't have control over the manufacturer, but we do have control over the motor vehicle dealer who's trying to get this off-premise permit. And in order to obtain this off-premise permit in a location outside of where you're at, right, you have to provide us a letter from the manufacturer saying that it's acceptable to them. We're not controlling the manufacturer, we're still just controlling the motor vehicle dealer, but they're gonna have to go to their manufacturer and say, I need something from you to go along with my application for my off-premise permit, saying that I can do this in Craig, Colorado, and yet I'm in Denver.
And I don't know that the manufacturer will do that.
So then they won't be able to get their off-premise permit for Craig.
Because the manufacturer is gonna get probably barked at by one
Craig
side or
Ford.
the other. They're gonna
Yeah,
get
Denver Ford
barked
and
at
Craig
by
Ford.
whoever's backyard
Yeah.
the off-premise is gonna be.
If Craig
Why
Ford
did
is
you
trying
allow
to come
it?
to Denver, they've got to get something from the manufacturer saying, yeah, we're okay with you having a tent sale in Denver.
The reality there too is the manufacturer won't let that Dodge dealer go to the stock show either.
So say the question, what's that question, John?
It's, when the manufacturer's just gonna say we're out, that means things like the stock show and the state fair where traditionally people do, large franchise dealers do go to this. If the manufacturer's not gonna get involved at all, they're not gonna be able to do those things anymore either.
Ken Stevenson's
Well, those are-
Wild West Show.
Right.
Yeah.
Oftentimes, those are done by the manufacturer, though. Their sponsorships by the manufacturer, not by the dealer, the licensed motor vehicle dealer per se. That's a broader sponsorship, right? Local dealers don't sponsor stock show vehicles. That's, Dodge pays hundreds of thousands of dollars for that sponsorship,
I
right? with the
recognize
stock
that,
show.
but there is a dealer that's there that has salespeople that are there hawking the product
Oh,
too.
hopefully not on Sunday. Sorry.
No comment.
381 last fiscal.
Wow, 30 a month.
And we couldn't give you a breakdown as to how many were new
Right.
versus how many
Right.
were independent.
And can you give a breakdown of power sports versus zero?
Zero power. sports.
Zero, because there's not anything that says that they need one.
Oh, that's right.
Did you notice how quickly I could
Yes.
answer that?
That's why we're here.
Well done.
Well, and that even becomes problematic because you get into these outdoor shows and the dealer that's selling a trailer with their power sports is required to get an off-premise permit, but the dealer right next to him
Right.
that is only selling power sports, they
don't
can
have
get in there
to.
for free,
Yeah.
from our
That's why
perspective.
we're having this meeting. This is where Jerry dropped the ball again.
I'm still trying to figure out how relevant market area plays into this.
Steve, I just don't think manufacturers are gonna get involved in this fight.
I don't think that,
They're
Well,
not.
And I
mean,
know
that's-
they're not, so that.
So you're basically
it
saying by
protects-
requiring manufacturer approval, you're gonna not permit new motor vehicles dealers to have them?
To get one in an area that is gonna compromise their territory.
Well, let me play the devil's advocate.
Okay, I don't know.
yeah, that's part of the problem. A lot of times, they want you to sell only in your relevant market area. So if you turn around and ask them permission not to, would the dealers that are outside the relevant market area have a cause of action against the manufacturer for breach of their agreement?
Well, and are the manufacturers gonna, or the dealers gonna start getting crosswise with the manufacturers because they're really close to meeting a certain tier in their incentives and they're slow walked or denied a little, yes, they can go have an off-premise permit.
Right.
They're gonna say, well,
Right.
you cost me a boatload of money because I could have made that next tier.
Yeah.
I mean,
And one of the things to keep in mind is, on the new vehicle side, the franchise agreements do not give any dealer an exclusive territory. They give you a relevant market area where they expect you to be sales effective, but there is never, I've never seen an exclusive, it's different on the RV side and maybe in the power sports side, but
It is.
but in the new vehicle side, there are no exclusives, only relevant market areas where dealers expected to be sales effective. So, that's,
Right.
there is no exclusivity. And so dealers are expected to sell as many vehicles as they can, regardless of where they go.
But I just have a question for you. Given the way that we regulate manufacturers and where they can locate a dealer, if the state's allowing a manufacturer or a dealer to move into another dealer's relevant market area to sell product, that will have an impact. It can't possibly not have an impact on that dealer in their relevant market area. So is the state facilitating I don't know about that. I mean, I'm not saying they are, but my question is that if you give somebody else a temporary license, which is what, call it a permit if you will, to go sell in someone else's relevant market area, doesn't that convolute things quite a bit when it comes to sales numbers and who's selling what and who's relevant market area? And
Certainly could.
yeah, and that's the part that I always wonder about the permit, is the impact, because those quotas, if you will, those sales numbers that have to be met are completely disrupted by going, if someone on a regular basis, for example, even 2-3 times a year, comes in there for a weekend event, that disturbs that relevant market area. And there's very few places in this state you could find that by stepping, outside of that market area, outside of that 10-mile area, that stepping right over the line, you're not going to step into somebody else's relevant market area, because you are.
Yeah, and there's huge investments involved here.
So that's the only thing
Manufacturing.
I've often wondered, about the whole thing, just from any individual dealer's perspective. It could be different. One dealer, nobody comes into their relevant market area. But you mentioned, or someone mentioned, these smaller dealers going to a larger market.
Uh-huh. Yes.
You're rarely going to ever see a bigger dealer go to a smaller market.
Right.
Well, and if I'm being accused by the manufacturer, Ford's saying I'm an underperforming Ford dealership, but every week I have somebody in my backyard in my relevant market area selling vehicles, it's.
Well, but see, that gets me to it may be okay for the state, but are you facilitating a problem by doing it?
If you're asking my person, I hate this regulation.
I know.
There's probably no regulation.
That was a general question for everyone.
Probably no regulation.
I know how you feel. You mentioned this to me a couple of times.
Well, Steve, let me just drive a big wedge in this. You said, okay, so dealer gets an off-premise permit to go into somebody else's relevant market area and needs permission from some kind of authorization from the manufacturer.
Right.
What about getting authorization from the other dealer?
Are you going to supply boxing gloves too?
Who's going to go ask?
Yeah.
So we have had a franchise dealer, a fairly decent franchise dealer in Grand Junction, get an off-premise permit for a parking lot in Glenwood Springs, in the backyard, sort of in the backyard of the same franchise. That's the one that maybe started all of this.
That's a little problematic. Particularly, in the metro area, it's not going to be as impactful, but, again, if you've got Steamboat Springs Ford that goes to Craig, to the Moffett County Fairground at their annual, rodeo to set up an off-premise to sell, Ford trucks, that relevant market is impacted.
Well, and even if it's not the relevant market, because let's say, I know we've had this happen in the Pueblo area. We've had a Pueblo franchise dealer, I don't remember, let's just say it's Ford, that got a permit to go to La Junta and set up a tent sale in La Junta. There wasn't a franchise Ford dealer in La Junta. There was a franchise Chevy dealer. So La Junta is this little community that sells a lot of Chevys, and I'll have the manufacturers wrong, but sells a lot of Chevys to their clientele that are the farmers of that area, and all of a sudden, boom, for 3 or 4 days, there's a Ford dealership right there. So they don't sell as many Chevys.
Yeah, so you can affect the manufacturer and the retailer.
Yeah.
Franchise dealer with the moving premises.
Well, let's go back to the ambulances. Let's go back to the ambulances. Broad Northwest puts a body on top of a Chevy or a Ford frame. Do they need to get Ford's permission to sell that somewhere now? I mean, if they go to this trade show, do they need to get Ford's permission to go to that trade show because it's on a Ford chassis?
And it is sold on an MCO. I mean, it's got a dual.
Yes.
It's got the
two
chassis
MSOs.
and the.
Wouldn't that depend on the agreement between the supplier of parts and the individual who slaps them all together?
Well, That's the question we're looking at.
Yeah, that's what I'm
That's-
saying. But I mean, ultimately, that's what it boils down to. I'm looking at what you'd have to examine to answer your question. And to answer your question, I think you'd have to look at the relationship between those two and how it is contractually. Because once they cut loose of that body, if there's something in there that says, you know, we're licensing you essentially to sell a component of Ford and they don't have other restrictions on it, they can sell anywhere they want to.
Let's not lose focus too, that we have a
We're
lot
not,
of.
we're just, I don't know, we're having fun.
Let's not lose focus that this is not only though for franchise dealers, because we have used dealers.
Yeah, that's a good
that go-
point.
That go into other used dealers sort of area. Now, they don't have a relevant market area, but they're right there across the street all of a sudden for 3 or 4 days, selling used vehicles and they're not there normally.
Yeah.
And so that is disruptive to.
Do the used dealers, I know they don't like that, but they would, I think, have a different historical perspective on that, because if you look at the way used car dealers have been placed, you have 6 of them in a row.
Correct. But do you have the 7th one all of a sudden?
Yeah, so, you know, I don't know if adding somebody comes in there for 2 days, but if you're gonna come in there for 2 days and there's already 4 dealers there, I mean, it's a different dynamic, I think, from the perspective of used car dealers. I'm not saying it may not be disruptive, but they're far more, they're much more used to having 20 other dealers within 2 miles than a franchise dealer.
We've also seen used dealers all come together to have a
That's,
group
yeah,
event.
and that's stuff, they do that? I thought that groups of used car dealers would get together and do that. Yeah, and that's the other way, because it's a whole bunch of dealers getting together. So that's why I say I'm not
But
so
anybody
sure.
can participate, you're not excluded from playing.
So that's why it's kind of, it
Make
is
the
a little
investment,
bit, it is a
you can
little
do
bit
that,
different
yeah.
than the franchise deal,
Yeah.
from that perspective.
And then we have the outliers. We have a couple of used motor vehicle dealers who get other used motor vehicle dealers' inventory onto their lot by having them get an off-premise permit. Totally confusing the buying public as to who they're buying the vehicle from.
Right.
The franchise dealer's putting it on the used dealer.
Yeah, we had that too.
So what's the call to arms?
Well, I think this honestly, this is really something that I got great confidence that Michael Darman is going to solve this.
He's not getting paid either, is he?
Oh, yeah, he gets paid handsome.
No, he's being paid, no, by his client. See, I don't have a client, remember that.
So that's all right.
I'm a lobbyist, I don't.
I mean, every time we debate this, there's all kinds of issues here, and
And
they're all
people on
good
both
issues.
sides of it too.
Absolutely.
Yeah, and you have strong arguments on both sides of the issue.
Interesting.
What's the power sports gonna say about when we put this regulation in place?
Well, when you get to the power sports, you know, there's the state fair and the stock show are ones that extend longer than 6 days. And at some of those events, you know, I don't know how I don't have the statute in front of me, so I can't tell you if that's recited, if there's a different litany or not. I guess I should know that, but I don't. You'd have to take a look at that and see how it parallels this, and I just dawned on me now that I should have done that.
Well,
And it is different for them because they don't have to take that Sunday break.
Oh.
Yeah, see, they can.
See, that's why
they
it's
can sell
different
on-
for them.
Yeah, and that,
Sunday is also.
and the same goes for trailers.
That Sunday break makes the difference.
What discussions have there been just limiting it to certain events? I mean, Nashville Western Stock Show, Colorado State Fair, county fairs. Is that a potential solution that's been discussed?
I don't know that we've discussed that, but potentially that's doable. I know that number 2, and Michael's exactly correct, that has to be cleaned up because there's some things that aren't correct in there right now, and we do have events now that Greeley Independent Stampede, that used to only be a 6-day event or 5-day event. There's 2 or 3 people to get, 2 or 3 dealerships that get off premise, but now that's extended to, I think, 8 days or something like that. So should the Greeley Independent Stampede be put into paragraph 2? Should we add some more events into paragraph 2? But Brad makes a point, should paragraph 2, should we look at expanding paragraph 2 to solve the problem? I don't know.
Well, I think Tammy's point of defining consecutive is important. You can't get one every week for the same, that's location, that's it's a valid, and that's certainly within the board's authority, right, to define that, what consecutive is.
Most power sport, the only other place that I can think of, and it's usually on a weekend basis, is indoor motorcycle racing, like Supercross or Arena Cross, that kind of thing. Dealers will set up, they'll sell space to dealers to display, and so they'll get an off-site permit for those kinds of events, which is, I don't know if racing, I don't know that racing is that kind of a deal for the franchise automobile dealers like it is, but a lot of the product being off-highway vehicle stuff, they can race them literally inside a building. But that's the only other place I can think of. The stock show, I mean, from my perspective as far as, but if you're talking about extended events, the only extended event I'm aware of that they would go to is the fair or the stock show that exceeds a couple of days from the power sports side.
How long is the Sportsman's Expo?
I think that's only 4 or 5 days.
Okay.
Do you have anything longer than that? You got the auto show and you got the stock show. In other words, are they covering everything that?
I don't know, Jerry.
They're not, it's,
Well, I keep asking questions you don't want to disclose. I apologize.
I don't know, I just really, that's a factual question. I don't know.
Okay.
I'm not your lawyer and I can't answer your legal questions, but you asked me a factual question just now that I don't know the answer to.
Sure, except your factual questions are all from my legal questions. We're going to have a judge decide what's a matter of law and fact. I don't trust you. No, I'm just kidding.
It's a mixed question.
So here's where we're at with 1 and 2. We're at the same place today that we have been for probably 3 or 4 years.
Right.
And so I have the intestinal fortitude to try to solve this some way. I don't have a suggestion how to solve this other than continue to debate it, look at what has been proposed, by CAVA to see if there's any validity in moving along those lines. But I got to tell you, this has got to be solved. It has to be somehow. We've got to get to something that everybody is relatively comfortable with. I don't know how we get there. I'd be very disappointed that if we move forward with no changes to this regulation, based upon the debate we've had over the course of the last few years. Okay, so take a deep breath. Let's do the same thing. This is one that, again, perhaps in the next few days, people can kind of put something on paper and throw out some rough draft things, rough draft ideas, and we can come back and pick that up next Thursday, not this coming Thursday, next Thursday. Okay, let's look at number 3. I hate to look at number 3. The books and records of each dealer, excluding financial statements, tax returns, shall be open to inspection Monday through Friday between 9 and 5 by the board and its agents, representatives with cause, including ongoing investigation, compliance audit, sworn complaint ordered by the board. All records, including financial records and tax records, shall be provided upon subpoena by the board. So here again, this is the power of the executive secretary that was delegated in another regulation to subpoena records. I believe that, I personally don't think this is broken, but I believe some industry members do think it's broken.
I think it could be clarified to say principal place of business. Even though it's implied because of where it's located in the step, in relation to 12.6.102 subsection 23 now.
So you're thinking that this can move to principal place of business? Is that what you're saying?
No, it's located under the definition of principal place of business as the regulation, but based on our discussions of 1 and 2, with off-premise locations, I think it should just be specified that it's the principal place of business. I don't know if there's been issues with that.
Well, the problem is the dealer's not required to keep their records at the
Right.
bank. They, in general, they are, but they can have them in locations other than the principal place of business.
Right.
Okay.
Assuming they notify the
Yes,
division.
they
Yeah.
have to tell the
Right.
board where
Okay.
they keep it.
Yeah.
And keep in mind the Electronic Transactions Act,
Mhm.
which permits people to maintain their records electronically,
Right.
which presumably is in some cloud or off-site location. And I've had this discussion with Bruce on behalf of clients who do in fact do that. They have only electronic records, only electronic deal jackets, which they store in some secure location, not necessarily at the principal place of
Okay.
business. So, but, you know, the Electronic Transactions Act is designed to trump all other statutes that may conflict with it unless that statute specifically says you shall maintain paper.
And I guess I should have phrased that differently. Has there been an issue with this regarding that?
Not regarding that.
Not regarding
Not location or
the
anything.
books and records. There's been issues regarding subpoena power and just say, taking the records by subpoena off the principal place of business.
And, you know, and I know that has been an issue with my client, and I will tell you that there are situations where I think you absolutely have to have the originals. Those are situations where there's alleged to be forgeries or document alterations, and I understand and agree with that. But just as a general rule, take the record and not allow the dealer to make a copy of it is problematic. And you know, the dealer, in addition to their obligations to the auto industry division, has obligations to the federal government as well to maintain privacy and maintain the confidentiality of the record.
That's what this is speaking to. This is speaking to the subpoena. It's not whether or not you can make a copy of it, but does the division have the authority to go in and get books and records, excluding financial statements and tax returns, I mean, deal jackets, without a subpoena? Is that what you're?
No, we have some dealers that allow us, that give us the deal jackets without the subpoena. They would rather
Right.
do that. We
Right.
have some that require subpoena, and I don't have a problem with that. The issue is, when we issue a subpoena a lot of times for 30 days of records, 30 days. Small dealership, that could be 20 deal jackets. Large dealership, that can be several hundred.
Right.
You know.
Right.
So we take those deal jackets,
Off
take them
premise,
off
yeah.
premise so we can
Do what you
analyze
need to do,
them
right.
here. And the issue has been that we shouldn't be taking them off the site because it talks about the inspection between these hours, okay? So the problem is, it's kind of the dynamics of what we're trying to accomplish and being as fundamentally fair with the dealership as we can. We're trying to accomplish a complete and thorough investigation. And if we go in and we're only, if we said we can only go between 9 and 5 and inspect the records, generally my subpoena goes out and one investigator goes out and gets the records or asks the dealer, can you supply these records to us in the next 20 days? That's generally what the subpoena says. And if we're only saying that, if it comes down that we can only look at the books and records and inspect them between 9 and 5 at the dealership, then what I'm going to have to do on these horrific cases, I'm going to have to send 10 investigators into the dealership to do this records inspection on these heinous cases. So do we want, so I'm serious, but it would not, maybe not 10, but 6 or 8 investigators, they're piling up and looking at records all the time. So it's that, where is that balance at in that issue?
To not be intrusive with 10 investigators landing at a dealership because all we can do is look at records versus, you know, and can we take this deal jacket and bring it back to you next Tuesday?
Okay.
And the franchise dealers, and I understand the franchise dealers' position, problem is that when we remove the records, we're removing personal identification information that they're responsible for. I understand that. But we're government employees and we're responsible for that too. So that's my comeback, but legal battle, where's that gonna come down at?
And it's not just the maintaining the privacy, but it's also the dealership's ability to defend itself if it doesn't have its records anymore.
Well, but the thing is, like Bruce was saying, the subpoenas are usually issued 20 days out. The dealer has plenty of an opportunity to make copies of those records as well.
So
We've taken a position, Mike, probably in the last 18 months, that we are issuing those subpoenas 20 days in advance or something like that, giving them plenty of time. The only time we ever go through the door and say, I want those records right now, here's the subpoena. If we think that there is going to be mischief, and that's very, very rare, that there's going to be doctoring of the deal, Jack.
Yeah, we had one recently where the investigator did demand the file the day he showed up at the dealership. And I think we did get a copy of it made before the original was turned over to him, but that was one issue. Just on a typo, Leland, I think the word "or" needs to be between complaint and order on the fourth line.
Yeah.
So, probably...
Where is the statutory authority for this, just to clarify that? The principal place of business, you're required to maintain these records, but where's the statutory authority for the auto industry division to get those? And that's where I would suggest this regulation needs to end up.
That's a great point. I'm not sure it's in the definition.
No, it's not in the definition. It basically says you've got to maintain these records at your principal place or some other place if you get permission, but the access to it is what this really gets to.
Right, and I'm pretty sure that years ago when the board promulgated this, they were promulgating it for the ability for the overall inspection of those records.
Right.
Does it land under the right statutory authority? That's a great question.
Okay, so I would suggest that subpart 3 get moved to wherever that statutory authority for the auto industry division now lies under our new 240.
It may lie under 105, we'll have to look.
Yeah, it's in the new one.
Michael, what I would just, this is so crazy. I think I said recently, I just can't even believe how long the legislature has seen what it did on this rule, and it just did it again by allowing functionality to exist within a definitional structure.
Mm-hmm.
The trouble is, it is enforceable in theory within those functions that the statute tells it has. So it has functions. And what we'll end up doing is, even if we move it, we're going to still probably have to reference as authority this definition that has functionality in it, because we can't change it, right?
So we may be referencing more than one statute, which we do.
We do anyway.
Yeah.
1053B.
B, yeah, that's where
you're
I
seeing
put it.
Yeah. I'm not going to accuse you of the unauthorized practice of law.
That's where I, the layperson, would put it.
Look at this, he won't let me ask a question and he won't answer mine. What the hell am I gonna do?
Well, I guess it's gonna,
Get an attorney.
See, there you go. I'm not a lawyer, I can't represent myself.
So aside from the fact that maybe it belongs somewhere else.
Right.
What else, some other things that might need to be changed in it might be? I mean,
Well, I circled with cause because it's not defined,
okay.
but
and that's circled too, by the way.
yeah, I just, was a flag for me, but
I mean, I don't want to come back to the next meeting and say, hey, we found a new home for it, it belongs in 105.
right.
But
And
then have the wording,
by the way,
know.
yeah, and I think I understand what cause means. You've got some reasonable suspicion that something's going on at a dealership, that you need to look at these books and records. So, I don't know if you want to say with probable cause, try to adopt a criminal standard for issuance of the subpoena, something along those lines, but, that's obviously an issue. I mean, I know that you guys just don't show up to look at records without a reason.
On a signed complaint or on the board on its own motion?
Yeah, that's defined after with cause, including ongoing investigation, compliance, audit, sworn complaint, or order of the board. So there's those 4 categories of things which are cause, but I don't think it's.
My problem with that is there's issues outside of those 4 that are still with cause or reasonable suspicion or something. Self-generated cases, we would not have a signed complaint. And I know years and years ago, the board kind of dug their heels in that we had to have a signed complaint. Well, that's really contrary to consumer protection.
It is.
It's real contrary to consumer protection. So,
How many compliance audits do you guys do?
last year, probably 0.
Answer?
That's going to be, we're gearing up that program again when we get the decision item, the new investigators hired and trained.
That's why I asked for that checklist yesterday.
Of what it takes to have it.
Yeah, which,
Right.
0. None.
Okay. Well, in any event, that was my only concern with it. I don't know what the answer is. I just raised the question of what does with cause mean.
Yeah, I had a circle too. I don't know that I would, and I want to think about this. I think probable cause may be too high. Reasonable suspicion, and a criminal standpoint, reasonable suspicion is lower than, you can make a
Right.
traffic stop on reasonable suspicion. You don't have to have probable cause.
But to get a subpoena, don't you have to have probable cause?
Well, who determines probable cause when I issue the subpoena, though?
The judge.
Yeah.
And
Well,
in a criminal
judge
case, the
issues
judge issues the subpoena, right?
No, I issue the subpoena.
Oh,
The judge
here,
issues
but in
judge
the
issues
criminal
a
context.
search warrant.
Right,
And then you do have to have you have to establish probable cause to the judge's
right,
satisfaction, yes, on a search warrant.
right.
But the problem with reasonable suspicion is in a compliance audit, we're not gonna have that. We're going in on an educational contact that has no reasonable suspicion, probable cause or anything. We're there purely in an educational capacity.
Oh.
So how do we not look at the records and
Under
effectively do
compliance.
this?
Education.
True.
So I mean, why not just remove with cause? I mean, it's a regulated industry. We should be able to look at the records. Mr. Dalrymple might not like that answer. But
Well, yeah, and again, John, I don't necessarily disagree with that, but I wonder what the statutory authority is for it. I don't think 105.3B that we looked at earlier, Chris, is that broad.
On a compliance inspection, the goal of that is, the real goal of that is truly education. So you walk in and you look at books and you look at a lot of things, including books and records. And if there's something in the books and records that isn't right, that isn't horrible, you just ask them to gain you're trying to gain voluntary compliance.
Right.
So before we would be able to do that, we'd have to look at a book and records to see that.
The UCCC does compliance audits at dealerships. And they send a letter in advance, and they sometimes ask the dealers to prepare a spreadsheet to say, show me all the consumer loans that were indirectly created through your dealership. Sometimes they actually send an auditor to the dealership, but they give you a heads up that this dealer is going to show up in the next 30 days and wants access to your books and records. And that's a pretty clear statutory scheme under the UCCC. And that is becoming more and more commonplace. I'm seeing more and more UCCC compliance audits. And they look at all the UCCC issues, interest rates, compliance with TILA, all those sort of consumer finance issues that they have jurisdiction over. So, you know, dealers are used to those compliance audits from the UCCC.
And I would be very opposed to giving dealers a heads up that we're coming through the door. I'd be very opposed to that.
Well, I think for what purpose? So again, you use the example of mischief. That would be one example where I think advance notice would not be required, but if it's just a pure compliance audit, to say, hey, we want to make sure that you're using DR 2434 in every deal, and we're going to be out next week to look at your deal jacks to determine that.
Our sister agencies don't do that.
Yeah. Okay.
On their, they do compliance audits and they do not do prior warrant. I mean, we walked through the door at times and said, we want to look at your books and records. Well, you don't have an appointment, so we're not going to show them to you.
Right.
No, time out.
Right.
The UCCC is pretty good about scheduling the time.
Right.
To do that.
No, they are. They are absolutely, Steve.
You know, if you come with the last day of the month or the first day of the month, it's.
You know, I think the real hot button issue for new car dealers on 3 is removal of of original documents.
I get that.
And you know, to the extent we can clarify those situations where, you know, the original is going to be gone, I think that's okay.
Well, let me throw this out because it goes in something you said. When in the electronic age,
There's no
original
right.
anymore.
Right.
So I know that some of your clients, but I know AutoNation a year ago, I think they're doing everything electronically.
Right.
So when their counsel contacted me, I said, well, okay, but yes, this is 2016, but do it, no problem. But when we walk through the door, we want to be able to, within a reasonable amount of time, have somebody sit down in front of a computer and bring those records
Up
so
and
we
be
can
able to
look-
print them out for you.
Look at it, yeah. So
No, that's reasonable. I don't have any problem with that.
So those are never originals anymore. So.
Yeah.
And 10 years from now, there will never be originals outside the hour that document's created, and maybe not even then, because you're going to do everything electronically. You're going to do an electronic signature with a finger or something like
Right.
that. We do that all the time now, so
Right.
it's another point that where the industry is going. So.
Right.
Well, as we're talking here, realized that what has not been done, you know, despite everything that Tammy worked up with other parts of this rule, none of us, to my knowledge, ever examined the way all of the agencies in the state of Colorado are operating around their subpoena power and around their search powers. And almost all of the agencies have such authority. So, you know, probably one of the things I'll try to do is look at that, at least a little small survey of some of that. What Bruce had to say about the revenue agencies is one thing, but maybe there's some guidance in language that we could find in one of the agencies in DORA or elsewhere, so.
It's like everything else in society. If we are going to be able to look at books and records, subpoena or just walk through the door, 85% of the dealerships, there is no problem whatsoever. None. Maybe 90%. It's that 10%
Right.
that all the real bad consumer harm is. So we have to think about how are we going to protect the interest of the integrity of the industry, the interest of the division, the interest of the board for those 10%. And not, you know, create a problem for the 90%. Okay. So seriously, Mike, you'll probably go back and talk to your client about number 3,
Yeah.
number 1, 2, and 3.
Yes, sir.
And I think that Leland can maybe throw out some of the old stuff.
Yeah, I'll try to-
Last
I'd like to see that tiered. I remember seeing it when Tammy did it, but I doubt I saved a copy of it anywhere, so.
We've had 3 major revisitations, and I'll look for the latest iteration of her work.
And if you would just email it to me,
Yeah.
Leon, I'd appreciate
I
it.
can email everyone that
Okay.
has an interest, yeah.
Thank you. Now, staff, we're running down to the end here, but staff, help me on number 4, whether or not we think number 4 is broken.
I think we just wanted to move it. Was the only note I had from our last meeting. Mhm.
So maybe 117.
Yes.
Mike, this is the regulation that you called me on and we talked about it, and then I pointed this out on that.
Yeah.
That's where this one is at, so. So everybody take a look at that. Now, do we have a power sports? So proposed, again, Jerry, we don't have anything for power sports, so, wow.
I'll try to have the same conversation with you at the same time. I'll do more unauthorized practice.
I do think that, I mean, because of the example that John gave, I do think if we're gonna have off-premise for motor vehicle dealers, we probably ought to have something for power sports too, so. The example John gave was perfect. Okay, I think I said that we would be done by 3:30. It is 3:45. My apologies. Probably enough today because it's enough for today. So here's, the next meeting is scheduled, of this group is scheduled for next Thursday, the 28th at 9 a.m. This is a sizable amount of, although I think we've agreed that some of this doesn't need, some of these don't need anything, so that helps us out. But I think we have a sizable discussion coming back on this regulation for sure. So I don't know that, I guess I'm gonna say we'll reserve the whole day and see how it goes. There may be a need, like Mr. Domu said, for a third stakeholder meeting. Wow, I hope we don't go past 3. I would like to get it done in 2, but that may be unrealistic. We may need to do it in 3 to get it right. I mean, the key is we got to get it right. So here's what I would like to do. I would like that the group, if you're going to put anything in writing, that you attempt to get it to us. Today is Tuesday. You attempt to get it to us in writing by close of business next Tuesday, because we're gonna have to turn around and do some blast emails on Wednesday, then maybe even that.
Maybe earlier.
Maybe earlier.
I think it depends on what you want to do. I mean, if we're, this is kind of like a group discussion on that, because we have touched on, by my count, 30 topics within the context of off-premises sales. And some of these are hot issues, some of them are not issues. I think if we could get people to focus, and I mean really focus on the hot issues, what's the most important for each person's group or individual interest that we really take up? Because this could turn into otherwise a very big shotgun blast of activity and nobody gets much done. I mean, if we streamlined it to the very most important things for the people, then we have a very good discussion of it. But regardless, if you only turn it in on Tuesday at the close of business, then all that will come out of this will be a collation of everyone's materials sent out sometime on Wednesday for a meeting we're having on Thursday morning. That doesn't seem like much turnaround, even to read what people write. I'd rather go at least with Monday. How's that?
And if we go with Monday, I guess where I always want, I I always want more than we're gonna get. I mean, by that, I'd like to next Thursday have a rough draft.
Oh, sure.
A rough draft sent out, but we're not gonna get to a rough draft. There's just too many issues. So, close of business Monday.
Yeah.
It gives us a couple of days to look at things, but I know that Mike is really concerned, and I get it, that we have fast-tracked this so fast trying to get all this stuff done, but it's the nature of the beast in rulemaking. I mean, it's just the way it is.
How do we spend so much time on material particulars? It seems like we met like 8 times on
Which is why he failed at his mandate to get a certain number of rules done.
If you
because we
remember
spent too
though,
much time on that
what
one.
happened to material particulars, just, the material particulars, the actual regulation, there was not a lot of controversy there. The controversy was the form. The form was.
Well, we had to change the form after.
Well,
But the regulation, I mean, we had, how many stakeholder meetings did we have on that one?
I think we did 4.
Maybe.
It was not fast track like this. I can tell you, I'm not gonna have anything for you by the close of business on Monday. I'd be lucky to have anything by the close of business on Tuesday. I wanna be realistic with the
I
group.
get it.
Okay,
I get it.
all right.
Mike, is there any way to have CADA blast a request out to its membership to just give raw information input? I mean, I just don't know.
I suppose there is, but ultimately it's got a large board that makes the policy decision. So, with 260 members,
Yeah.
and we've got people on both sides of the issue in this room, we're gonna have
That would be a nightmare.
people on all sides of all issues on this, particularly on the off-premise permit thing.
Yep.
So I'll do my best, but I just want you to understand realistically.
I get it.
Yeah.
I
The only last thing I would say is, on the set of these, which is numerically the most, where there does not seem to be much or any controversy, then what I'll do is package that, and that will come out as sort of wave your hands over this material so that we have that out of the way. That'll include, minor tweaks have to be made, either because we've identified a couple words here or there, if we've identified a reference that needs to be corrected. Jerry and I might be able to have something together as a proposed thing for the ANSI requirement that would fit his material. And that could, we may get very far along on everything but the one that's the big issue.
Has 240 and 298 been integrated into the code that's available online? Chris is shaking her head yes, so the
Yes,
answer to that must be
it finally showed up, what was it, last week?
Yeah, I think so.
Yeah, it was very, very recent. You did not miss a meeting. It was very, very, very recently.
Okay.
It's in the books now.
Okay.
Yeah.
So we just.
And is it on in your statutes and regs that are online?
We have a link that goes to the,
New one.
Yes.
Yeah, it just goes to
the
where.
official.
Link through a link.
Yes.
Yeah.
And the FCC frowns upon those.
I know, but we
Okay.
couldn't do it all.
We have a link to
A link that has a link.
LexisNexis and a link to the Secretary of State.
Okay.
Technically, that's the policy of the Department of Revenue now for that. They're allowing the divisions, they're not encouraging the divisions, but they're allowing the divisions to move, like we've done in the past, move the regulations under the statute.
Right.
But they don't like that.
Okay. I like it. I've used this notebook for years with the statutes and regs right in it. So,
Here. So that's what you'll see on our website right now is those links. Because
Okay.
we have not integrated that back in, and I
Good.
don't know when we will be able to get that done. That
Get
is
my
a-
notebook updated finally.
Big lift, that's a heavy lift.
That's a heavy lift for the division.
Yeah.
So. Okay, with that, let's call it quits today. Thank you for
Thanks, everybody.
your time, very
Thank
much
you.
so, and we'll see you Thursday at 9 o'clock, next Thursday, 28th, 9 o'clock.